I want to turn your attention to a very concerning story about a student journalist and activist currently in hiding and how Google helped the government gain access to his personal private information. When Donald Trump returned to office, he issued a series of executive orders targeting students who participated in campus protests, specifically protests in support of the Palestinian people. As a result, student activists found themselves in the crosshairs of the federal government, and daring to speak out while on a student visa made some people particularly vulnerable, even though, just to be clear, the Constitution offers the same freedom of speech protections to you no matter who you are. It's not about citizens or not citizens in America, but that's another story for another time. I want to tell you the story of one international graduate student at Cornell University, Amandla Thomas Johnson, as told by several several outlets, including reporters Sean Musgrave and Jessica Washington with The Intercept, and Benjamin Leans and the Cornell Daily Times. Let's go back to 2024. Johnson, a British student activist and journalist, along with his friend Mamadou Tall, were involved in pro-Palestine organizing on Cornell's campus. According to the Cornell Sun, both of them faced temporary suspensions from the university after attending a protest which disrupted a career fair. Tall sued the government to block its targeting of international students who were protesting in support of Palestinian rights. Then the government went after Tall. Johnson seemed to see the writing on the wall, and in April of 2025, Johnson fled the country over concerns that he would be deported. He told The Intercept that he decided to leave after a friend who was detained at the Tampa airport was handed a note with Johnson's name on it and was asked repeatedly about his whereabouts. And on May 8th, 2025, he received an email that his immigration status had been terminated by the federal government. Now, the Cornell Sun says the record on Johnson's student visa program stated that his status was terminated based on a section of the, quote, Immigration and Nationality Act, which allows for a consular officer of the U.S. Secretary of State to revoke, quote, a visa or other documentation of any alien at any time in his discretion, end quote. Doesn't quite tell you exactly what was going on. According to the Cornell Sun, Johnson feels that he was targeted because of his past as a journalist reporting on what he called the War on Terror beat. All right, you're asking me why I'm doing this story? This is where Google comes in. On that very same day, May 8th, 2025, the day that Johnson was notified about the termination of his immigration status, he also received a brief email from Google informing him that the company had handed over his metadata to DHS following a government subpoena. But according to The Intercept's reporting, Google turned over his data before notifying Johnson or giving him an opportunity to challenge the subpoena. And it wasn't until recently that he learned the full extent of the information that the government asked for and that was handed over. According to a copy of a subpoena obtained by The Intercept, DHS demanded a wide array of personal data, including usernames, addresses, an itemized list of services, including any IP masking devices, telephone or instrument numbers, subscriber numbers or identities, and even credit card and bank account numbers. This is from Google. The subpoena reportedly did not provide justification for why ICE was requesting such private information, except that it was required, quote, in connection with an investigation or inquiry relating to the enforcement of U.S. immigration laws, end quote. That's all they had to say, apparently. And the subpoena requested that Google, quote, not disclose the existence of this summons for indefinite period of time, end quote. Now, Johnson believes that ICE requested the information to track and eventually detain him. His legal team told The Intercept it still doesn't know the full extent of what Google actually shared with ICE, but his bank and credit card numbers were attached to his account. Google didn't respond to The Intercept's request for comment. And there's another layer to this story. According to The Intercept, the subpoena that was issued to Google wasn't what you normally think about, like for guys like me who aren't lawyers who understand subpoenas through law and order. This was what's called an administrative subpoena. We've talked about it before on this show. Unlike the traditional subpoena, which requires a court order by a judge or on behalf of a grand jury, administrative subpoenas can be issued by federal agents themselves without approval from a judge or a magistrate or a grand jury or kind of anybody. The Trump administration has been using these administrative subpoenas in its immigration crackdowns, increasingly relying on this particular legal tool to obtain personal data from tech companies, from universities, from employers, and from social media platforms. Joining me now is Faiza Patel. She's the Senior Director of the Liberty and National Security Program at the Brennan Center for Justice, and technology journalist Jake Ward, who's the host of the podcast, The Rip Current. He's the author of the book, The Loop, How AI is Creating a World Without Choices and How to Fight Back. Welcome to both of you. Faiza, I'm going to get to you in a second with the law, because this is important. But before we get to the law, Jacob, let's just go back and explain to people that these tools we use every day have everything on us. They have all the information. And I think most people who are watching this do not understand that one little subpoena to one of your tech companies, Google, AT&T, Verizon, whoever you get used for your tech, can give the government more information than it would have taken them 5 years to get a decade.
That's absolutely right, Ali. I mean, we're talking about a world in which, a guy in a van with a pair of headphones on outside your house doesn't even come close to the kind of surveillance that our modern information ecosystem has on us, right? I mean, we're talking about a world in which, every time you buy a cup of coffee, there's an entire world of data brokers tracking that purchase and coming up with the routines of your life. And in the commercial sector, that's just to, get an ad in front of you, right? But in the new surveillance world that we occupy, even though Congress has tried to make it illegal for the federal government to snoop on you, for the most part, these companies are simply buying out of the private sector the kind of information they need to get to understand where you're going to be at any given time. And that is a loophole that has created, I would say, one of the greatest surveillance panopticons we've ever seen. And in the case of this, of a subpoena and going into Google, that is, of course, an even deeper thing here. But I think it's important for everybody to understand that, the Fourth Amendment doesn't protect a third-party data relationship necessarily. And we're in a world now where when an outlet like ICE or anybody else wants this data, they don't need a subpoena. All they have to do is go buy it on the open market, Ali.
Yeah, this is two topics here. They can get information on you without any subpoena at all. But Faiza, the fact that they can get it for almost nothing. Like I think it didn't occur to many of us in the post 9/11 days that we were really giving the government the right to not have to present things to a court or a judge or a jury. They literally write up a subpoena, hand it to Google. Maybe Google tells you about it. Maybe Google, and I'm only using Google because that's the example here. Right. Maybe they give you a right to try and go to court or not.
Yeah, I mean, I think there's a couple of things that are important to remember with respect to subpoenas. So one is there's this idea, which is about now 20, 30 years old, that the kind of information that you get from a subpoena is less private, is less revealing than the kind of information you need a warrant for, right? That's for intercepting a phone call or reading your email. So historically, there's been this border, if you will, between content and non-content information. And non-content information was traditionally thought to be less intrusive, less impacting on privacy. Now, that is no longer the case, as we've all learned post-Snowden, and particularly in the last sort of 10 years or so, how easily all of this information, these records, if you will, can be used to paint a very detailed picture of your life, right? They can identify whether, you go to a gun shop, whether you go to a mosque, whether you go to an abortion clinic. All these really intimate details about us are revealed by this kind of information, which is available to the government via subpoena.
So this makes these students who felt that their information was given out unfairly. The fact is, and Jacob makes this point a lot, the government can just do a lot more with administrative subpoenas. They can actually go on these fishing expeditions because there's no way for you to prevent the government from getting your behavioral information.
Well, there's two things, right? The standards are very different, right? It just has to get us to write a subpoena, which can be contested before a judge, sort of ex post facto, right? It's not before you go in and get the information as it would be normally with a warrant. It's a later determination, and often it doesn't happen. And the standard is much, much lower. The standard is about relevance to an investigation, and courts are generally very deferential. So even if you manage to get in front of a court, you're probably going to lose on most of these subpoena requests, in contrast to a warrant where you have like a much stronger standard and judges are, will inquire as to what the government is doing. So you're sort of, you're in a bad position as an individual in both ways. One, the government can do it on its own. Two, you may not get notice of it. And three, even if you do,
you're limited in what you can do about it.
You're limited in what you can do.
Which goes back to Jake. This is the bigger problem here, and that is that in a simpler, non-digital world, in theory, you had certain protections because if you didn't give people information other than a guy sitting outside of your house with headphones and, listening to you, they couldn't get it. Now everybody has everything all the time. We willingly give up information that pertains to our lives in very detailed ways, including women who use apps to track their pregnancies. All right. That the government can then access, to Faiza's point, using a very low bar to get a subpoena.
That's absolutely right, Ali. I mean, for me, the most sort of illuminating part of this, in my experience, interviewing these CEOs, is just how cavalier they are about the permission they seem to feel we have given them. I once interviewed Wonton Tat, who's the head of a company called Clearview AI, which is a basically all-in-one facial recognition system. It scrapes your face off of any places on the internet that it exists and gives it to a law enforcement database for a sort of perfect identification system. And I asked him at the time that launched, well, is this thing, I mean, do you think that people understand that they have given you this information? Have I given my kid's face to law enforcement? I don't think people understand that bargain. And he said, I think they do. I think anybody who has willingly posted themselves on the internet understands that they've given up their right to privacy. But that's not the bargain that we struck in the era of social media, right, Ali? I mean, the whole feeling was this is a private relationship, or it's just me and my friends, and this is the mission creep we've seen over time. And then that takes you into a world in which now you have the same vendors who do battlefield surveillance in Yemen, in Gaza. Those folks are now in charge of the contracts that the Department of Homeland Security and ICE are using to surveil American citizens. You combine all of that together, and I think, the bargain that we thought we were striking with these companies is very different than we imagined, Ali.
I remember people talking about the Patriot Act back then and saying, well, if you're not doing anything wrong, you shouldn't got nothing to worry about. Why, don't worry about it. You're not a criminal. You're not. Guess we all should have thought a little harder about that and listened a little more closely to those people. Thanks to both of you for being here. Faiza Patel is the Senior Director of Liberty and National Security at the Brennan Center for Justice. Jake Ward is a technology journalist and the host of the Rip Current podcast. We'll be right back.